We want to take you now to Fulton County Court in Atlanta, Georgia. That is where a hearing about DA Fani Willis is underway. A judge is deciding if she should be removed from the Trump election fraud case. The former law partner and divorce lawyer for the special prosecutor is now on the witness stand. So let's watch.
I do not have knowledge of it starting or when it started.
Terrence, you told me that it started when they were both municipal court judges, though, correct?
That is incorrect.
You never confirmed in writing that it was, instead of magistrate court, it was in municipal court when they started dating?
If you're speaking of the text message, you can go to that text message and you can read that text message, and I will explain the text message to you. But you and I did not have a conversation about when it started. You asked a compound question of magistrate court versus, you said it was magistrate court, you said magistrate court conference, I'm sorry. And then you asked another question. I said no, municipal court, nothing else.
I'm referring to a different conversation. I asked you, do you think it started before she hired him?
And I'm going to object. This was covered in the previous hearing where Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of and actually used in an attempt to refresh his recollection, and he explained exactly what he's explaining here before the court. So this is repetitive and unnecessary, and so I would object to asked and answered and relevance at this point.
All right, perhaps we'll get there, but I think first Ms. Merchant has the right to draw his attention to the exact, potentially inconsistent statement.
Thank you, Judge. May I approach him?
So overruled.
This is the text I give you. So you. This is one I gave you at the last hearing.
And for purposes of the record, I believe, Ms. Merchant, you tendered, was it the entire text chain as an exhibit?
I only tendered a few of the texts, but I did give the state their courtesy copies last time of the exhibits.
Was this one tendered?
This one was not tendered. No.
All right.
And I'm happy to tender it.
Well, we'll just take it as it comes. Whatever you
We're at, I think we're at 39. I will wait to mark it, but I think we're at 39. May I approach it?
You may.
All right. So, Terrence, do you remember telling me that it started when she left the DA's office and was a judge in South Fulton?
I see the message there, but I don't recall. I do see that message, but I do not recall.
You don't recall texting this?
I look back at my text messages through that we've had. I see that message, but I do not recall that. No, ma'am.
And when I asked you if you thought it started before she hired him, and you responded absolutely.
Your Honor, I'm going to object as to the source of the information that Mr. Bradley allegedly gathered this from. There's been absolutely no foundation, and based on the arguments at the last hearing, that a lot of this is based on gossip, innuendo, assumption, and privileged information. And at this point, Ms. Merchant has not provided a foundation as to how Mr. Bradley would have any information that she keeps referring to.
All right. I think that's... Go ahead, Ms. Merchant.
I didn't ask him about the source of the information. And under Rule 621, I can impeach him with any inconsistent facts. This is an inconsistent fact. I can impeach him with any contrary facts.
Sure. Why would it be a relevant impeachment if he actually has no personal knowledge of this?
If he doesn't.
Sure. So I think you have to lay that foundation then, so that'll be sustained.
Do you remember telling me that it began?
Well, that doesn't address the issue.
No, I'm not. I was just asking if you remember telling me as opposed to the text.
Sure.
Do you remember telling me that it began?
Well, no, and then you're going into the substance of it, which we haven't determined whether he actually knows or how he knows.
You told me, in fact, you corrected me when I said magistrate court. You corrected me and said it was municipal court.
Yeah.
Do you remember that?
Same objection, Your Honor.
This is the exact same issue, right?
Well, I'm asking if he remembers that. He hasn't answered that question yet.
Right, but the relevance of whether he remembers it isn't established until we know how he remembers it or why he knows it. If that makes sense. I guess not.
Sorry. How he knows it? I'm just asking if he told me that.
Right.
So I wasn't asking how he knew that. I wasn't asking the source of that knowledge. I was asking if he told me that.
Sure.
That was it.
But that's the point. It's how he knows it.
Right.
The source of his knowledge, the state would contend, is hearsay because it's gossip and innuendo, which is what was indicated at the last hearing.
Well, it may not be hearsay. It may not be gossip. We haven't really gotten there yet. We don't know how he knows what apparently he's telling her, and I think we need to figure that out before we can go any further.
Yes. And if the source of the information is a witness who've testified, then it's not hearsay. So when did the relationship start?
I cannot answer that.
When was your first knowledge of the relationship?
Objection, Your Honor. He's already answered that question multiple times today. He said he had no idea the timeline or when it occurred. That was one of the first questions that Ms. Murphy asked.
I didn't ask when. I asked his first knowledge. He testified he has knowledge that they had a relationship. I asked him when he first got knowledge of that.
Okay, so if the question is, when did you first get knowledge, I think we can start there.
That was the question, yes.
All right.
Thank you. When did you first get knowledge of their relationship?
I've said over again that I didn't have any personal information where I could personally say when it started. I've said that time and time again. So I don't know when the relationship started.
And that wasn't my question. So my question is, when did you first gain knowledge? I didn't ask the source of the knowledge, didn't ask you to comment on the validity of the knowledge. I asked when you first had knowledge.
We'll get to the how, Mr. Abadi. So I'll note the objection, overrule it. You can answer that.
Just for the record, and I appreciate your honesty, but he said he has no personal knowledge, so it's clear he had to gain the knowledge, not from hearsay.
He could have gained it from
Sure.
Mr. Wade.
Well, I mean, most of us learn things from hearsay. The question of whether it's admissible, right? And that's what we got to get to. So,
I apologize.
Right. When did you first get knowledge? I'm not qualifying what type of knowledge. I'm just asking when you first knew about the relationship.
I don't know how to answer that. I mean, so I can't give you a date if you're asking for a date. If you're asking me, how did I get the knowledge? It would have come directly from my client.
Right.
So help me understand.
I think you say you can't answer that question. You don't know the date. So that's the answer to the question.
But I said that 5 minutes ago.
We have to make it clear.
Yes, sir.
Next question, Ms. Merchant.
So you don't know the specific date?
No.
Do you know if can we narrow down the timeline? Did you gain knowledge in 2019 of this relationship beginning?
I'm going to object to this line of questioning, as he said he does not know
Sure.
when he gained
All
knowledge.
right.
He doesn't know the specific
That's
date.
fine, Ms. Merchant. I think I'm overruling that. I think we can try to see if he can narrow it down based on goalposts.
Thank you.
19, I would probably say no. I mean, I don't have anything that there wasn't a specific date. There wasn't a football game. There wasn't something that I can attribute to him telling me whatever. And so you're asking for a date. You're asking for a year. It's still a date. And at this time, I am telling you that I do not have the date.
Let's try this then. So you received a contract from Ms. Willis January 2021, correct?
Can I see the? Yes, I think so.
Exhibits are, I think. Okay.
I think if it was from the exhibits, I think it was 21. Yes.
And I don't want to belabor the point. You admitted those
Yes.
when you were here before.
Yes.
If those documents that you looked at last time
Yes.
said January 2022, that's okay.
21.
I'm sorry, 21. You're right. Thank
And
you.
it was, I think, renewed in 22.
It was, yes. So the contract date was that we have in the record is January 25th, 2022. So using that date, at that point, had they begun their romantic relationship?
Of 2022.
January 25th, 2022. 2021, I'm sorry. When you got your first contract?
I don't recall I don't recall any specific dates. No, ma'am.
You remember when you got that contract, though, correct?
I remember I had the contract, yes.
Okay. And you told us last week, or I guess it was the week before now, you told us that Mr. Wade brought you that contract, essentially told you about that contract.
That is correct.
So Ms. Willis is not the one that brought that contract to you directly. It was Mr. Wade.
That is correct.
At that point in time, they were already engaged in a relationship, though,
I'm
correct?
going to object, Your
I
Honor.
can't say that.
Characterization of what Mr. Bradley just said. He just said he does not remember. There's nothing specific.
He doesn't remember the exact date. I think the question now is to reference it or tie it to maybe some other event that he might remember.
I agree with Your Honor. She asked that specific question. He said he does not remember any specific dates after signing the contract. That's exactly
Sure.
what he just said. This is
All
asked
right.
and answered.
I know, and we're getting to the end of it. So, Ms. Merchant, you don't have much more to pull on here, but he answered that last question, so what's your next one?
And Judge, I didn't hear the answer if they were in a relationship January 25th, 2021.
Mr. Bradley, do you recall the question?
I recall the question, and I can't tell you accurately whether or not they were in a relationship at the time. You asked me about him bringing me a contract. I said he did bring me a contract, and that is accurate.
Do you remember knowing Ms. Willis prior to her taking office as the DA?
I had very little contact with Ms. Willis. I knew her through my business of coming down to Fulton, if that's what you're asking. Yes.
You knew her through the business. So you had met her prior to your contract?
I'm going to object to relevance at this point as to why we're here today.
Sure.
Judge, he doesn't remember much of anything right now, and so I'm trying to create a timeline to hopefully piece this together.
All right. Well, I'm not seeing really the likelihood that that's going to have any success. I'll let you ask a few more questions, but if he doesn't have a date, then I don't know that you're going to be able to create one today.
Okay, thank you. So the time that you had this contract from January 2021 until January 2022, did you come in and out of the DA's office?
Yes.
Okay, and so were you able to witness Mr. Wade and Ms. Willis interact during that time?
I'm going to object. This has been asked and answered. It was addressed at the last hearing about Mr. Bradley's access to and from a specific room to pick up files. And Mr. Bradley said that he rarely saw them together, but this was
Yeah,
answered.
I think the only avenue that was closed at the last hearing was his personal knowledge, potentially through, well, actually, no, if he testified, it was that he had no personal knowledge. It's knowledge that conveyed to him that was cut off at the last hearing. That's really the only thing we hadn't been able to explore, unless you correct me if I'm wrong.
Knowledge that was conveyed to him by
Somebody else. That's that he claimed at the time was privilege. I found that it's not. That's what we're here to explore.
Okay. Do you remember telling me that not many people knew where they met?
I'm going to object as to relevance, as to his personal knowledge, which is what 602 requires.
Yeah, I mean, we're back to the same point, Ms. Merchant.
His personal knowledge is what I'm asking him what he told me.
But he hasn't yet told you how he knows that. And so unless you can establish why he should be testifying on this at all, then there's no relevance.
And I don't know how he knows that. That would be
Then
the
ask
next.
him.
That would be the next question.
Then
But
ask him how he knows it.
I first have to establish that he said that.
No, you don't. You could go the other way around.
When you told me that it started when she left the DA's office and was a judge in South Fulton, where did you gain that knowledge from?
Well, I'm going to object because his testimony a few minutes ago is that he did not recall making that statement.
All right, I'll overrule that. Mr. Bradley, answer the question if you can.
Repeat the question.
When you told me that their relationship started when she left the DA's office and was a judge in South Fulton, where did you obtain that knowledge from?
I was speculating. I didn't have a no one one told me I was speculating.
No one told you that?
No one told me that.
You were speculating based on things that had been told to you or things you had observed?
So I'm going to object as to the nature of this line of questioning, because the witness has made it clear he was speculating as to how or what he knew. And if it's speculation, it's inadmissible before this court.
All right, but the motivations for his reason for speculating would be admissible, so I'll overrule that.
Thank you, Judge. Was this speculation, when you told me that, was that based on things that had been told to you and things that you had witnessed?
I never witnessed anything. So, you know, it was speculation. I can't tell you anything specific, if that's what you're asking.
You can't tell me anything specific as to why you speculated about that?
No, this was however many years ago. I mean, I don't recall, but no, I don't.
Did you have any reason to lie?
I don't know if speculation is lying, but
Well, let me just show me where in this text it says you're speculating.
you didn't ask me if I was speculating or guessing.
I didn't ask you, but tell me if it says anywhere here that
No,
this is speculation.
if this is the same one that you just showed me, it does not.
And you're welcome if you need to look at your text. Is there anywhere in here that indicates that you didn't have knowledge of this
No.
relationship?
Your Honor, I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. He's explored that. He said it's speculation, and he didn't get it from any source other than his own speculation.
Sure,
So
I think we're flushing that out, and I think it's her right to have a little leeway on this if he's an adverse witness.
Thank you, Judge. And Judge, these speaking objections are clearly coaching the witness because he's regurgitating.
Your Honor, I object and take offense to that comment. I'm objecting based on the law, and I'm making a record for the court. So I take offense to that comment. It's not the case.
All right, well, I think we can start with objection, the grounds, and the rule number, and then if I need more, I'll ask.
Thank you.
All right.
Thank you. What did Nathan tell you about the relationship?
Objection, hearsay.
Nathan has testified. It's not
Yeah.
hearsay.
It's still hearsay. It's an out-of-court statement being brought in for the truth of the matter asserted. So hearsay.
Judge,
Yeah, this would be for impeachment by contradiction, which would be an exception to the hearsay rule, and admissible as substantive evidence, and the privilege issues are overruled.
thank you, Judge.
Well, I think you just overruled the privilege objection, but we don't know when he's talking about. So we've already established that December 2018 was the date of the privilege.
Sure, and that's something I covered in the in-camera hearing, and I'm, based on what he told me in that in-camera hearing, I don't believe any statements to this effect were covered by privilege.
And Judge, I just want for the record, because sometimes the record doesn't reflect where people are looking, and that when I ask a question, Mr. Bradley is looking at Mr. Wade and his lawyer to wait for them to object, and they're clearly interacting somehow in the court. So I just want the record to reflect that, because it wouldn't otherwise.
It's there now.
Thank you.
A question was put to you, Mr. Bradley.
Judge, one of my lawyers is sitting right in the back.
We don't
That's
have to go down
behind.
that rabbit hole. You can look wherever you want.
Yeah, and I'd never looked at Mr. Wade or his attorneys. That sounds true.
All right. Mr. Bradley, question was put to you.
Repeat the question, please.
Yes. So I showed you, or I asked you, I'm sorry, the last question I asked you was, what did Nathan Wade tell you about the relationship?
Same objection, Your Honor.
And that's already been ruled upon.
I recall him stating that at some point they were dating. I can't tell you what date that was. It was made in confidence. We were in the back of our office. Our offices were the only two in the back. There was no one else present. That is all I can tell you at this time.
One time?
One time.
You only had a conversation with him one time about the relationship?
Objection, asked and answered.
No, I think that's clarify for a thorough and sifting cross. Ms. Merchant.
I do not recall any other time that he mentioned that they were in a relationship. No.
You may not. Okay. So you talked about this one time, and you said you don't know when it was, though, correct?
That is correct.
Was it before Mr. Wade, before you got the contract in Fulton County? Let's start with that.
I do not recall.
Okay. And how did it come up?
Say again?
How did it come up?
I do not recall how it came up. It was in the back. I know where it occurred, in our offices in the back. I can't tell you what we were discussing prior to that.
Okay. Did you receive an email from me on January 6th with a motion attached?
I think I did, yes. Yes, I know I received I don't know if the date is January 6th, but yes, I received that,
Okay.
yes.
So you remember receiving that?
Yes.
The date, okay. And you reviewed it, and then you and I spoke about it? You recall that?
Did we speak over the phone, or are you saying through a text?
That's what I'm asking you. If you
I
recall
can't
speaking.
remember whether it was text or phone or
But you recall us speaking, one way or another?
one way or another, yes.
Okay. And where I was trying to confirm the facts in that filing.
I think I remember there was a line of about the accuracy of how much money that my office, the law office of Terrence Bradley, have received, and whether or not that was going to be in the motion or not.
Well, there wasn't a discrepancy. I had kept that out. You asked me to put that back in, correct?
I recall you that may be accurate, yes.
And you thought, because you thought it might be suspicious if you were left out of the motion.
No, I think we discussed that it should reflect the accuracy, because the accuracy was that I received, I had a contract and received $74,000. And I think you had put in there that Mr. Campbell had received a certain amount, and then you also had put in there that Mr. Wade had received a certain amount. But there was not anything in there originally, and I said that it needed to be accurate. I needed to be accurate as far as that I had received $74,000.
Right.
That's correct.
Because you did not want anyone knowing that you had talked to me.
I would object this for relevance.
Be biased. Overruled.
I wanted you to be accurate as far as the accuracy of our message or your filing.
Okay, so that was your interest was in accuracy in the filing.
I didn't reach out to you and say, send me a copy of your motion.
Right.
I didn't reach out to you to say that that I'm going to be in your motion.
Right. I asked you to review it for accuracy. Right?
For accuracy, and I just stated that it was inaccurate.
And the inaccuracy that you pointed out was the thing about your salary, or how much you had made.
That was the inaccuracy that I saw that jumped out, was the fact that I saw that I was left out when you had put
Okay.
the firm, the money wise. I did not, when I responded to that, it was for that specific reason.
Okay. And I agreed I would put that back in, that section back in, and
Correct.
I did put it back in, and I sent it to you again.
I don't recall getting a second email from you, no.
But you were happy that I put it back in, or that I agreed to put it back in.
I'm going to object this to relevance.
Yeah, we need to get to more material aspects.
Yes, Judge, I'm moving along, I promise. So you did ask me to put that back in.
Well,
And answered relevance.
well, you didn't answer that last question, so overruled.
You did, can you confirm you did ask me to put that back in, for it to be accurate?
Yes, that's correct. I said that, yes.
Okay. And then I asked you if everything was accurate, and you said, looks good. Correct?
I recall you asking that, but the looks good was applying to the accuracy of the 74,000. That's it.
Okay. So when you reviewed the motion, and you specifically pointed out that one thing that you found inaccurate, you didn't point anything else out that you found inaccurate in that motion, though, correct?
No, I did not.
And that motion alleged that their relationship began when Ms. Willis was in municipal court.
If I can reread the motion, but I don't recall. But if that's what it says, but I did my saying that it looks good was when you put back in the 74,000 into your motion.
Okay, and that wasn't what I was asking. What I was asking is, you didn't tell me that there was anything else inaccurate in the motion, though, right?
But I didn't state that anything was accurate other than the 74,000.
Now, when I told you that I had this motion that I was preparing, you asked me to send a rough draft.
No, that's incorrect.
May I approach, Judge?
You may.
Which page are you showing?
They're not page numbered. It's January 6th.
I just see it.
Yeah, of course. I can show you just all the text. Look and see if this works. So we had been talking, and you asked me to send you a rough draft, and I told you, okay, but I didn't want it to be leaked before I filed it. Right?
That is correct. That is correct.
So you're the one that asked me to send a rough draft.
Yes, that's correct. Yes, that's correct.
And that was at 10:08 on Saturday, January 6th. And then you got an email from me with that rough draft at 10:25 that same day, correct?
Yes.
You didn't even look at it.
If it says 10:25, then I know you sent me an email.
While he's looking at it, I'm going to object us to ask and answer. We've been through the fact that he sent him a copy of the motion, whether he specifically said rough draft or not, and then asked about the accuracy. He's explained his answer, and I've object to ask and answer. So.
Understood, Mr. Vine. We're getting there. Overruled for now.
And then I responded when we were talking about that footnote that we were just talking about. I said I took it out, but I can add it back, and you said yes, add it back. Remember that?
I answered that yes.
And then I said anything else, anything that isn't accurate, and you responded looks good. You recall that?
Let me see the.
Of course. And there, I don't know where the exhibits are. They were admitted. That refresh your memory?
It says looks good, but as I stated before, I was responding to you putting me back into the motion for receiving $74,000 in a contract.
But that's not what this says. This says, you said yes, add it back, and then I said anything else, anything that isn't accurate, and you responded looks good. So you weren't responding to put it back in.
Your Honor, I'm going to object. This is not his motion. He wasn't the affiant of the motion or verified the contract.
Overruled, Mr. Body.
I'm just talking about his personal knowledge.
I've said
No personal knowledge.
twice.
Overruled, Mr. Abadi.
I've said twice that the looks accurate was, or I've said more than twice, was for the $74,000.
Do you remember telling me about Nathan and Fani coming to your office and spending time together at your office?
No, I mentioned, I do recall testifying on the 16th that she had come to our office.
And that was before she was elected as district attorney, correct?
I recall that that was when she was district attorney, because I said that there was a meeting held at my office.
And who was at that meeting?
Now, I can't tell you that. I don't recall.
But you know Ms. Willis was there, Mr. Wade was there.
It was at our office. Actually, Ms. Willis was there, and there were other people there. Mr. Wade was not in that meeting. He was in the back. I wasn't even in that meeting.
Why did she hold it at your office then?
I have no idea.
You also remember telling me about them spending time together at her law office before she took her job.
I don't recall. Do you? I don't recall. Do you have something to?
Well, what I'm asking is, so let's back up a sec. So Ms. Willis rented a law office from Evans' firm, or Andrew Evans and another lawyer, I think Stacey Evans. You have knowledge of that, correct?
No, I'm going to object to hearsay.
Well,
How does he know the information? That would be the correct question.
okay. Ms. Mershon?
I don't really know even how to respond to that. Hearsay. I'm asking if he knew that she rented
Yeah,
offices.
he may have been there. He
Right.
may have seen a business card or something at some point. I think you can answer that.
I've never been to Ms. Willis's office when she was in private practice. I've never dealt with where she rented. I didn't even know where her office was. So,
Do you remember, though, knowing that she rented an office
yes.
from the Evans?
Yes.
You did know
That is correct. Yes.
Okay. And do you remember telling me that Mr. Wade and Ms. Willis would rendezvous at that office?
I'm going to object to, again, hearsay as to how he knows that information. He said he has no personal knowledge. And
He did
just-
not say he has no personal knowledge, Judge. He hasn't even answered it.
No, he said in general he had no personal knowledge. So it's not been established the source of how he would know this because he said he's never been to her office.
All right. Ms. Mershon, if you, I know you're trying to impeach him by a prior inconsistent statement, but unless you can first back up and show why each statement is actually something that he had knowledge of, I don't know if this is going to be relevant.
And Judge, I'm not even there yet, but again, a speaking objection, and so now I would anticipate what our response is going to be next. I didn't ask anything that was objectionable, but these objections are coaching the witness. I asked if he had knowledge. That's it. I didn't ask, did someone say this to you? I didn't ask, what did this person tell you? I asked if you knew.
Well, no, you're asking if you had knowledge, and then you say of something specific. So,
Once I get an answer to that, if he has knowledge, then I will follow up with where that knowledge came from.
all right, well, let's try again.
So my question is, do you have knowledge of them meeting at that office?
Objection, foundation.
Okay, all right, overruled.
Do you have knowledge of them meeting at that office?
I have no personal knowledge, if that's what you're asking.
I didn't ask that yet. I asked if you have any knowledge.
Objection, that would be hearsay.
Overruled.
Not if it came from Mr.
We don't
Wade,
know where it
Judge.
came from. So he said, how do you know, Mr. Bradley?
How do you know?
Any knowledge that I would have received would have come from my client at the time.
Okay, so you had knowledge of this place that Ms. Willis worked. What did you know about them meeting at that office?
Objection, hearsay.
It's not hearsay,
Overruled.
Judge.
How he knows it, and then you ask the next question.
All right, he's already asked the next question.
Can you repeat the question?
Yes. How do you have knowledge? What knowledge did, well, you just told us. You told us Mr. Wade told you. So tell us what Mr. Wade told you about Ms. Willis and Mr. Wade meeting at the Evans office.
Objection, Your Honor. Privilege. This clearly covers the time after December 2018 that would be covered by the privilege.
Yeah, overruled. You recall the question, Mr. Bradley?
I do not.
You re-asked the question, Ms. Merchant.
What did you learn from Mr. Wade? I was clarified that's where you learned it from. About Mr. Wade and Ms. Willis meeting at the Evans office together.
I don't object to asked and answered. He's testified that
He hasn't answered. We haven't heard an answer.
He testified he had one conversation with Mr. Wade in the back of his law
Judge,
office.
No, and his answer may change. So
Tip him
overruled.
off as to how to answer the question.
I can't recall what the conversation was. I do recall knowing that he would go down to the office or had been down to the office, but I can't tell you in what capacity or when or any of that. No.
Mr. Wade told you that they had sex at that office, is that correct?
I don't recall him stating that, no.
You don't recall it?
No.
So it's possible he did say that. You just don't remember one way or another?
I do not remember him saying that.
Do you recall that he had a garage door opener to either a house or a condo or something like that of Miss Willis's?
I've never seen a garage door opener. I've never been to Miss Willis's house. I've never been to, and I'm trying to explain, I've never been. So no, I do not have any personal knowledge of him having a garage door opener.
Let me ask the question again.
Yes, ma'am.
You didn't ask if you had personal knowledge, like as in you saw it. Do you have any knowledge at all from Mr. Wade or any source that he had a garage door opener to access one of Miss Willis's residence?
And I'll object to any source as to hearsay.
All right, depends on the source. Overruled.
No, I don't have any knowledge.
So when you told me that, did you just make it up?
Do you have something that shows that I told you that?
Yes, well, we're going to go through all the texts we can, but so was that made up though?
But I'm going to object because I
don't recall him having.
Mr. Bradley, just
I'm
a
going to
second.
object under 106 as the rule of completeness. I don't have that text message or any text messages that indicate that, Your Honor.
And I don't have, if it was a text, we had that conversation. I actually think it was when he was on speakerphone and Mr. Merchant was there, but I'm not sure. But I mean, if I'm asked to qualify exactly where that's from, I would.
Okay, so rule of completeness would be if you need to introduce other text to show the context. If you're saying you haven't seen a copy yet, then I think Ms. Merchant needs to do that before you can decide your next step.
And that's what I was asking him. If that was something he just remembers making up. If he doesn't, then that's fine. But
She referenced text messages and started to go into her packet of papers.
Sure.
That have text.
So you don't have a text message to that?
I would need some time to look through, and I don't remember if I have a text to that or if it was during a conversation. It was one of those.
All right, well,
And
he has now said that he has no knowledge, so on to your next question.
Okay. Did Mr. Wade tell you about the trips that he and Miss Willis took?
No.
You have any knowledge of the trips that he and Miss Willis took?
Objection, hearsay.
Overruled.
I do now.
Okay. But you did not before this proceeding?
I did not know until you text that you found that in the deposition of his divorce. I mean, not deposition, but something from his divorce.
Okay. And when you responded, doesn't surprise me, they took many trips to Florida, Texas, California. Those are your words, though, right?
I'm going to object as to relevance. He said he did not know, and he actually learned from Ms. Merchant the information.
He said he learned about certain trips from Ms. Merchant.
Okay, you can tie it down, but
Thank you.
we'll
He
see.
had no information about any trips that Ms. Willis and Mr. Wade took. That he learned it all from Ms. Merchant. That was his testimony.
Sure.
Judge, I'm
Maybe
allowed
the conclusion we reach. I think she's going to ask more than one question, though. All right, Ms. Merchant.
And if, Judge, just so we can be clear, if he said more than one version, that's all relevant. We're allowed to talk about the different versions that he's told.
All right, I've overruled the
Thank
objection,
you.
Ms. Merchant.
Do you remember telling me that it didn't surprise you that they took the trips that I found in the divorce file because they took many trips to Florida, Texas, California? And then you told me that they took the trip to California when she moved her daughter there because she failed out of FAMU. Do you remember that?
I don't recall that, but if I don't recall.
Okay. Judge, may I approach?
Sure. You may.
It's in one of the ones I gave you. Look at that and let me know if it refreshes your memory.
So when that,
Just first let me know if that refreshes your memory.
yes,
Okay.
yes.
So it's true that you told me that they took many trips to Florida, correct?
Per that, yes, but one of the messages is cut off, and you asked about some other trips, and I said, no, I didn't, I think. And that was specific to, at the top of that, it says, no, I didn't.
Yes.
And so that was to the trips that you asked me about. And I think before that, when you mentioned that you found all these trips, I think I said, oh, wow.
Yes, you did.
And
You did not know about all the trips that were taken, and you qualified it. You said, no, I didn't. When did it happen? And then the next text, which I can get, or you can look at your phone, or whatever refreshes your memory, you said was after you left, after the firm was dissolved, correct?
Subject to relevance.
Overruled.
It was after the firm. The trips that you said, no, you didn't know about. You told me those were after your firm had dissolved, correct?
I think you mentioned that they were after I left, maybe, or whenever you found them, and I said, no, I didn't know about those trips. So
you believe I mentioned that it was after you left?
I'm quite sure you have the text message, and I will refresh my memory.
Is it easier for you to refresh your memory with your own phone or with my printouts of screenshots?
Well, you have the printout, so I'll go.
Judge, the reason I'm asking is because I'm getting objections that I've cut things off, and it's just the nature of how you have to print out screenshots. So in order to avoid that, I'm happy for him to refresh his memory with his own phone, if that would be...
Well, I don't know if he's accepting your offer or not, so you're going to...
Would that be easier for you?
You can just provide the documents.
Okay. Let's see.
Can I have some water, Judge, please?
Yeah, let me see what we can do.
Sorry, Judge, I'm just trying to pull out all of the messages that you may need.
All right. Well, I don't really see, at some point we're reaching the cumulative point where we don't need to go through an entire 6-month text chain. You're making the point that he'd made some comments to you along the way that led you to believe he had more knowledge than today he's testifying that he had. And so if you've hit the high points of that, then I don't know what else we can cover that actually moves the needle.
Okay, I'll move on to the actual trips then. So you told me that they took many trips to Florida. That refreshed your memory. You told me that. Was that based on your knowledge from Mr. Wade?
That would have been based on anything that my client would have told me. I didn't have personal knowledge of whether they went or not.
The trips to Texas, and you're the one that typed to Texas. Was that based on your knowledge from Mr. Wade?
It would have been something that came from the client. I cannot tell you that I have any personal knowledge of any trip other than what would have been said by the client.
obviously, and I'm not asking if you went on these trips, I'm asking if you have knowledge from Mr. Wade. You also typed California. Was that something that you gained from knowledge from Mr. Wade?
It would have been from the client at this particular point. Yes, it would have been from the client.
And when you told me that the trip to California was to move her daughter out there, would that have been something you gained from Mr. Wade?
Thank you, Judge. Any knowledge that I have of any trip would have come from my client at the time.
You told us last week that Mr. Wade used your credit card one time. Do you know when that was?
I do not.
Relevance covered here today.
Well, I think this would be impeachment of Mr. Wade's testimony if Mr. Wade testified that he had never used anyone else's credit card before.
I object to asked and answered because it was covered during the last hearing where he acknowledged that Mr. Wade used his credit card.
Judge, I asked when.
Just when, okay?
I didn't ask, did he? I asked, when did he?
Let's go there.
I do not have any dates of when Mr. Wade used my credit card. I testified that we used the card for business and that throughout the business we would order paper or supplies or filing of depositions. I mean, the cost factor of cases is what I said, and that still applies today. Did he use my credit card? He did, but I can't tell you who he used that card, what the trip was for. I can't even tell you at this time where he went.
But he used it for a trip.
Yeah, it was for a trip, but I can't tell you where, when, why, or anything to that nature. Correct.
And he paid you back in cash.
I never testified that he paid me back in cash. I said that he would either pay me back, I said I couldn't remember. I do not recall. Sometimes he would write checks. Sometimes he would pay cash. And that still applies today, that I do not recall him paying me back cash, but I do recall him paying me back.
And this was when you were still, before your partnership split up, correct?
It would have been before I left the firm, yes. He wouldn't have used my card after I left the firm.
Okay. So we can at least narrow down the dates to that.
Of before I left the firm, yes.
Okay, great. And Mr. Wade gave you details about meeting Ms. Willis in Hateville or East Point, as it was called.
That's incorrect.
He did not tell you about that.
He didn't give me details.
He did not tell you about meeting with Ms. Willis at an East Point or Hateville apartment?
At this time, I don't recall. No, I don't recall.
Where did you get that information from then?
He's testified he doesn't recall if he even had that information.
I asked if he got it from Mr. Wade, and he says he doesn't recall. So then I asked where he got it from.
I do not recall where I got the information from.
Okay. And you and Mr. Wade were friends as well as business partners, correct?
We were friends in the sense of I've known him for years. Yes, we were friends.
And you definitely did not want to come and be a witness in this case, correct?
That is correct.
And it was after, and we talked about this earlier, that Gabe Banks called you and then Nathan Wade called one of your friends. It was after that that you hired Mr. Chopra to assist you in this matter, correct?
Was it after that? So I hired Mr. Chopra and I hired Mr. Graham. Now, Mr. Graham is here, and when I received the subpoena, Mr. Graham was here at the last hearing, but he also had to go out of town, but he was present. Mr. Graham, I called, and I had started getting calls from media, and I told him to respond to the media, I think, and that was somewhere around whenever you subpoenaed me. So it was, I can't tell you that it was that instance of those calls for Mr. Chopra, but I had engaged Mr. Chopra and Mr. Graham at that time.
Okay. I'm going to ask the question again because I didn't get an answer to it. After you got the phone call from Gabe Banks and from Nathan Wade to your friend,
I think it was before that, but however, I think it was before that is what I'm stating.
when you got the call from Gabe Banks, you called me immediately. Well, actually, you texted me and then you called me.
I didn't call you immediately, but yes, we did speak.
Okay. And you texted me about it as well.
That is correct.
And then we spoke after Mr. Wade called your friend, and
We have been listening to Terrence Bradley testify. He's a former law partner and divorce lawyer for Special Prosecutor Nathan Wade. Bradley was ordered there by a judge to, again, take the stand because they wanted to know about his knowledge of Wade's relationship with Fulton County District Attorney Fani Willis. This hearing is all part of an effort to disqualify Willis from the 2020 Georgia election subversion case involving Donald Trump and other co-defendants. A lot to break down in this very complex issue. So let's bring in CBS News campaign reporter Katrina Kaufman. She is also an attorney and has been very closely following this case. Thank you so much for joining us, Katrina. What did we learn from today's testimony? What was this point about the timeline of when the knowledge of their relationship? Why is that so important here?
Thanks for having me, Nancy. This is very crucial testimony because it really backs up Fani Willis and Wade's statements about when their relationship started. Essentially, the lawyer who's questioning in this case, Ashley Merchant, is trying to prove that they've lied on the stand at this point. She wants to show that their relationship began before Wade was hired on this case, which is part of their allegations. And when Wade and Willis testified the other week, they both said it started later. I believe it was November of 2022. So essentially this witness, Terrence Bradley, this is Nathan Wade's former business partner. It's his former attorney. And she thought that he was a star witness for her allegations, that he was going to prove them correct, and that essentially show that Willis and Wade perjured themselves. But this is going very differently than she had hoped. We can see she's getting pretty irate in there with her questioning, and it's because he's really going against all the things she's trying to prove right now with this testimony.
What is the backdrop to all of this? What's at stake here?
I mean, the case is at stake. They're trying to get Fani Willis and Nathan Wade disqualified. If Fani Willis is disqualified, it disqualifies her whole office. And that doesn't mean the case can't move forward, but replacing her would be a very complicated process. It would put the case in limbo.
And we will continue to pay attention to all of this. I know there's a lot of heated emotions there. We're going to dip back in. Katrina Kaufman, thank you very much.
Objection as to speculation as to how he thinks they will react.
I think it goes to the motivations of the witness overall.
And you told me that they will deny it.
That's written in there, yes.
I just want to, one last opportunity. You're an officer of the court, correct?
I am.
And you're under oath today?
I am.
Is there any of your testimony from today or the previous days that you want to correct?
That I want to correct?
Yes.
No, I told you everything that I've answered everything that you asked.
Thank you. Oh, Judge, just so the counsel and the state can have them, for the record, I can admit those few that I showed. That would be.
Well, they weren't ever tendered,
And
so it's just for.
I didn't know if they wanted to use them, but I'll hold on to them.
If they need to be tendered at some point, then we can make them part of the record. All right. Let me turn over to Mr. Sadow, if you're with us on Zoom.
Thank you, Hunter. I do have a few questions. First thing I'd like to know is whether the court reporter has defense exhibits 26 and 27 from the last.
We have a different court reporter this time. We had to have someone else fill in on such short notice, but I can potentially send those to you if you need them.
Well, I think I have working copies, but I want to make sure that the witness has a copy to look at.
All right. We can try to work through that logistical challenge. This is, you said, 26 and 27?
I believe that's correct. And 26, I think, is the same text messages that Ms. Merchant was just asking about. It was 2 pages. I stapled it together, and it is dated January the 5th of this year.
All right. I can print off a copy now, but why don't we start off with the questions that you have?
Okay, because that's where I want to. That's where I'm going to start, but I'll see what I can do to work through it.
Is that going to work? Here, I'll lean on to you. Okay. All right, Mr. Seda, why don't we start with your question, and we'll see if we actually need to get a copy of those exhibits in front of the witness.
All right. Mr. Bradley?
Yes, I'm here.
All of a sudden, I've lost you on the screen. There we go. Well, you're on the Zoom. You're on YouTube, but you're not on the Zoom itself. But not that I can see.
I'm here. I can hear you.
No, I think his visuals may be a little different, so hold tight, Mr. Seda. We could try to correct that. So that
Yeah, he was on. He was on when Ms. Merchant was asking questions.
We need to add,
able to see you.
we need to add a spotlight to to the witness stand and a spotlight to Mr. Sadow, and we don't need all the other boxes.
They are figuring out their technical issues there in court, but we have been listening to Terrence Bradley testify, and quite a bit of back and forth there with the defense attorney, Ashley Merchant. But Bradley, their former law partner, but crucially a former divorce lawyer for Special Prosecutor Nathan Wade. Bradley had been ordered by a judge to take the stand yet again regarding his knowledge of Wade's relationship with Fulton County District Attorney Fani Willis. This hearing, as we had mentioned before, is an effort to disqualify Willis from the 2020 Georgia election subversion case involving Donald Trump and other co-defendants. So that's why this is an incredibly important case. To discuss more on this, let's bring in CBS News campaign reporter Katrina Kaufman. She is an attorney and has been very closely following this complex case. So when we pay attention to what's happening in the testimony, I guess we'll start out just by asking what were we looking for? What were you looking for, and what did you take away from this?
Yeah, I mean, as we were talking about, I was really looking to see if he was going to blow up the timeline of their relationship.
And why was that important?
It's important because it would show that they potentially perjured themselves on the stand. I mean, one issue here is that just them having a relationship under Georgia law shouldn't be a conflict of interest. Like, ethically, it's not great. Optically, it's not great. But it doesn't mean that she can't be on this case and that they can't prosecute it accurately. Under Georgia law, the parameters are different for that. But really, they testified about a certain timeline of their relationship, that it began after she had hired him. And if they were shown to have lied on the stand, I think that would be a huge problem for Fani Willis. So I've been looking out for that.
And you hear all this back and forth about when did you know, and when do you think it started? When was your knowledge about this? And so it seems from the defense attorney's line of questioning and her tone in questioning that this is not going the way that she had expected.
No, she absolutely thought that Terrence Bradley was going to validate her allegations, because one thing we were talking about offline is that she had sent him a motion with these allegations, and he had responded to the email and said, looks good. And she thought that he was saying, okay, you've said everything that I wrote in this motion is correct. He's now clarified to say that actually it was just a salary that she had noted, and he was saying that that was correct. So she seems very flustered because she really expected a different testimony here. I guess they had a lot of back and forth, and she thought that he was affirming things that she said about the relationship, about the timeline, about trips they took, about whether they maybe slept together in a certain office of Fani Willis's. On the stand, he is not confirming any of this. He's saying he doesn't recall or that he doesn't have knowledge of a lot of it.
Sure, and you see her kind of hone in on what you knew and what you communicated to me in the course of us planning this conversation and this testimony today. Could the result of what happened here delay this trial, or what could any ramifications be from this?
from having to deal with all this. I mean, I think there's definitely an issue with the optics of this case now. People of the public is reading about this. It could influence jury selection later on. You know, it could taint people's visions of the case, of Willis. That could be a problem. In terms of the actual timeline, I'm not sure. It was supposed to probably be taking place in August. They never actually confirmed the date for the trial, so I don't know that it necessarily delays it that much. It's all dependent on Judge McAfee's view of all this testimony, of these allegations, what he decides about how this case is going to move forward, and if it can move forward with Willis and Wade on the case.
Yeah, with so much on the line, too. We really appreciate your input on all this, Katrina. We're going to go take a break right now, but then dip back into the testimony when we come back.